Welcome to today's masterclass. My name is Lisa Richter, and I will be your host today. On the off chance that you do not know about CSIA, we are a global nonprofit trade association with over 500 member companies in 35 countries. For system integrator members, the CSIA Best Practices Manual and CSIA certification are some of the more popular member benefits, but you will also enjoy a variety of others, including professional development, learning from your peers, and access to professional services experts, including insurance, financial, and legal, who understand the SI's unique business needs. For partner members, CSIA offers an ecosystem to grow your SI programs, understand your customers' pain points, monitor industry trends, and share your thought leadership. With thousands of qualified integrators and suppliers, the CSIA Industrial Automation Exchange helps SIs, industry suppliers, and manufacturers connect and do business. For SIs and partners, it provides a platform to support your content and SEO marketing efforts, position yourself as a thought leader, and nurture prospects during their complicated buyer's journey. In case you aren't a current member, now is a great time to join. Membership provides you many benefits, including a full lineup of virtual events and other resources for you and your entire team, from accounting to sales to operations, 365 days per year. Plus, CSIA dues are prorated, which means that if you join now, dues are half off because we are midway through the year, offering you a great value and a way to give CSIA membership a try. At this time, I would like to turn it over to today's speakers, Brittany and Brian. Take it away, guys.
Great. Welcome, everyone. Looking at the participants list, I see some familiar names. It's wonderful to see you all again. Some of you who I just saw in Denver for the CSIA Executive Conference. It was fantastic to get together in person with all of you. We are changing topics from what I talked about in Denver, which was on some of the current market forces involved in contracting and supply chain disruptions. And we're going to completely flip it around, and we're going to have my colleague Brittany talk about doing deals, the basics of mergers and acquisitions. So if we can go ahead and advance the slide. I will let Brittany introduce herself here in a moment, but as many of you know, I am the co-leader of our industrial automation practice here at Faegre Drinker. We're a full-service law firm with 22 offices throughout the United States, also in Europe and China. We help SI members negotiate contracts, work out customer agreements, handle employment matters with non-competes and employee handbooks. We handle corporate matters and tax, but what we're talking about today is M&A, mergers and acquisitions. So Brittany, if we can talk a little bit about what your practice has been, and then we'll get into the presentation.
Sure, that sounds great. Thanks, Brian. My name's Brittany Yoakum. I am a partner in the corporate group at Faegre Drinker. I have a general corporate transactional practice, but my focus is on mergers and acquisitions. Most of the deals that we work on are middle market M&A, but that can range from anywhere from less than 10 million up to around $200 million are typically the deal sizes that I personally work on. In addition to M&A, I also do just general outside corporate counsel work for companies who don't have in-house counsel. I've done financing deals in the venture capital space, and then also just the general commercial contract work. But my focus, like I said, is M&A, and that's the area that I'm most passionate about. And so I'm excited to have this discussion today.
Yeah, so when we're talking about M&A, I guess we're either talking about buying a company or selling a company fundamentally, right? So maybe we start on the sell side. If you can talk a little bit, what do you think are some of the reasons why in your practice you see business owners thinking about selling their company, given what's going on in the world and in the market right now?
Sure. So I have learned that this is a very personal decision to the business owner. So there might be a variety of reasons why someone makes the decision to sell, and it can be a difficult decision for many. So some common reasons that we might see are for retirement planning. So perhaps there's no in-house succession plan at the business. So maybe there's not any plans to pass the business on to the next generation, so to speak, or existing management may not be interested in selling the business. So as the owner is considering what their next step should be when they get to the point where they're ready to retire, transition into retirement, that may be a reason the owner's decision to relocate. So perhaps they, want to go to a different geographic area, live in a different area, and so are just, ready to sell the business for that reason. I also have a lot of clients who sell their businesses because they want to focus on something else, maybe related to the current business that they're in, or maybe they just want to go into an entirely new focus area. So I would say those are some common reasons, but like I said, it can be very personal, and usually there's, a lot of decisions that go into, making that final decision to decide to sell.
Yeah, it seems like some of the people that I know I've worked with in the CSI membership are what I might refer to as serial entrepreneurs.
Yeah,
that this might not even be their first business and are hesitant to start a new one before they've sold the old one. And this may be, number 3. So it sounds like that's your experience as well. If some of these transactions, either retirement planning or moving in a different direction, and it makes sense to kind of start a new business rather than capturing that within the existing business. Is that right?
Yes, absolutely. So they want to, capitalize on what they've grown in their existing business and then have a great new idea, and then having the exit first can help fund the new business, for example.
That's great. And as Brittany and I could probably attest to, for those CSI members who have been with the CSI Legal Plan for many years, we ourselves have gone through a few mergers and acquisitions. We were originally Baker & Daniels when I started, and then we were Faegre Baker Daniels, and now we're Faegre Drinker Biddle and Reith. And I don't think there's any plans to change in the near future, but we have lived the experience that we're talking about here today as well. So if a company does decide that it's thinking about at least opening itself up to a sale opportunity, what do you think it should start to do on kind of the front end of that process?
So I would say planning as far ahead as possible is key, because it can take a lot of time to gather all of the necessary information that a potential buyer is going to want to see when making that decision. So financial information, of course, you really want to position your business in the best light possible so that you can maximize value and not leave anything on the table. I say this not just selfishly, but because it will, be very helpful if you engage service providers at the beginning of the process, because accountants, lawyers, tax advisors, especially, if we get in early, then we can structure the deal or, spot issues at the front end that are actually, will save significant time in the future, because, sometimes there's reluctance to bring the service providers in until, maybe they see a buyer at the table, and it's really more beneficial for the seller to get those advisors in early on. I would say it's important to also think about who the most attractive buyer would be. So a lot of times owners may, be concerned about what the future of their business looks like. Of course, especially an owner that has built it from the ground up. They really care about their employees, want to see the business continue to be successful. So perhaps there's a certain strategic acquirer that has a good cultural fit, or, would otherwise just be a good buyer for that particular business. So I think an owner sitting down and thinking about those types of things as well, so that they can position themselves in a way that whoever that strategic buyer that they've targeted would also be interested in acquiring them. So a lot of times you think buyers are out there looking for, who do they want their targets to be, but the decision should be on the opposite side as well. It's often just as important for the sellers to want to find the right buyer.
So if a seller doesn't have kind of a dream buyer already picked out, I'm assuming they don't go to their local classifieds and put business for sale, 5 million OBO. Where have you, in your experience, had buyers come from? I mean, are these market contacts? Are these just, are there business brokers? I mean, how does a person who's thinking about selling their business start to identify potential buyers?
Yes, so an investment banker would be the best way to identify those buyers. The banker will run a competitive process. And so that's another example of a service provider that you want to bring in early, because the banker will gather a bunch of information, put together a PowerPoint slide, the confirmation or a confidential information memorandum that will go out to potential buyers. And then by running the competitive sale process, the banker can help identify the buyers and then maximize, again, the value on the transaction. Because if you've got competing buyers, then more likely to make the price go up.
Yeah. Anybody who's tried to buy a used car lately?
Yes, exactly.
Right now. So
yeah.
Yeah, a lot of buyers, not a lot of available quality businesses. So it sounds like, if I'm hearing this right, there's a couple different paths. One is this competitive process in which you kind of engage an investment banker or other sort of service provider that helps run a competitive process. And the other one would be, as the seller, you've kind of self-identified someone who might be a good potential strategic buyer. Maybe you've done work with them in the past. Maybe you know them from CSIA, for example, or through other industry groups, or they're at a different tier and they also do work for the same customers, but maybe you've been subcontracted to them and maybe they're, instead of hiring you, maybe they want to buy you. It sounds like those are both paths that potential buyers can be identified from. Is that right?
Yes, that's exactly right. And I would say a third path that perhaps some of the listeners today have already experienced is the seller may have already been approached by a potential buyer. That's very common as well. And when the seller finds themselves in that position, perhaps they believe that buyer is a good fit, right away they say, okay, I want to go through the sale process or see what the deal could look like with the buyer who approached me. Or maybe they realize, okay, there's interest in my business. I want to see who else is out there who might want to acquire me, because perhaps the buyer who approached me wasn't my ideal buyer, so to speak. So sometimes the buyer approaching the seller can be the beginning of the sale process, and what leads the seller to decide that to engage the investment banker and then go down that path. So I would say there's probably 3 different ways that are most common for a deal process to get started.
Okay, yeah, that third one being like, I'm the wallflower, somebody comes and asks me to dance, and maybe I don't want to dance with you, maybe I do want to dance. It turns out that opened my eyes to the idea about getting on the dance floor. So how long does the sale process typically take? I mean, once you've kind of gone through one of these 3 paths, what's in your experience the typical length of time until the transaction closes?
Say way longer than most people want it to be. So, I mean, it's good to go in eyes wide open, knowing that it's going to be a fairly long process. Once a buyer has been identified, I would say, 4 to 6 months, maybe 3 months. And this varies depending on the size of the deal. So the larger, more complicated deals tend to take a longer amount of time than perhaps a simple deal. Another way that a seller can try to shave down the amount of time, once the buyer is identified, is by doing that pre-work that we mentioned previously. So the more they have the information gathered and are prepared for the diligence process, which we can hit on later, which is also tends to be a favorite for both the buyer and the seller. Not really the favorite, so that's also something that can take a lot of time if the work wasn't done ahead of time. But I would say, to be safe, expect to be around 4 to 6 months. Can be shorter, can be longer, but just going in knowing that it's not going to be a quick process and it's really a marathon, not a sprint. I sold a house and I remember I thought that took too long. I'm like, why is this taking so long? Like this inspection and everything else and the back and forth. And that opened my eyes to be like, wow, I see what my clients go through, because you just want to get to the closing table, but it just takes time to get there.
Yeah, sure. I mean, big transaction on both sides. Somebody selling something they helped build and somebody taking on something that they didn't build, and they need to know what they're buying. I'm sure that takes some time. So what does that process look like? I mean, what's really happening during that multi-month period between buyer identified for the business and, you know, sitting down at the closing table and getting a check?
Yeah, so once the buyer has been identified, it's very important that the parties enter into a confidentiality agreement. A lot of times that actually happens before the buyer's identified if you've gone through the competitive sale process, because before the banker gives up any of the information to a potential buyer, of course, you want to make sure they're signed up to an NDA that they won't be disclosing or using your confidential information that's enclosed in those materials. So that's very important to have the NDA signed. You know, another reason why I say get the advisors in early is because I've had some clients who have not done a sale process before, perhaps it's a smaller business, smaller deal size. So they come to us, they've already given all this information. There was no NDA in place, and that's, you know, not ideal. So you really want to make sure that you are getting your ducks in line from the very beginning. So once you have the confidentiality agreement, the parties will negotiate and enter into what is called a letter of intent, often referred to as an LOI. This is not required for a deal, but I recommend it because you're outlining the main terms of the transaction, and it's non-binding, so you're not legally bound to the agreement. But when you're negotiating a deal, people tend to be very married to those terms, and there is just moral opposition if anyone tries to go against those terms. And it's important to go through those negotiations on the front end to set expectations. Okay, this is what the purchase price will be, assuming nothing comes up in diligence that will warrant either an increase or decrease in that price. You know, this is what the structure is going to look like, so then the parties know the tax impact on both sides. If there are any important third-party considerations, those might be outlined in the LOI. So really, it's just the outline, so to speak, of what your main purchase agreement is going to look like. And also important, I'm going to sound like a broken record, I think, by the end of this, of, you know, getting help from the appropriate folks on the service provider side, because M&A counsel should really be guiding you and advising you as you're entering into those terms. I think parties who haven't been through the sale process before, when they see it's non-binding, they think, okay, so I guess it doesn't really matter as much what's in here. We'll be able to change the terms in the future. It just makes the negotiation process much more difficult when somebody's trying to change the terms on either the buy or the sell side, unless there's a, you know, very important reason for that, such as a, you know, important customer goes away or something like that. But so anyways, the LOI just is going to outline all of those terms. The parties will agree and sign the LOI. There will be an exclusivity provision in that LOI, which is also very important, because the buyer wants to make sure the seller isn't going around and continuing to shop the deal while the buyer is invested in putting all the time into diligence and hiring their lawyers and all of that. So that period of time is negotiated as well, and the parties need to watch that carefully. If you start to creep up on that exclusivity expiration, you'll want to make sure that you extend that. And then the next step, once you have this signed LOI, the lawyers will turn that into a purchase agreement, which will be much, much longer than the LOI, but will outline all of those important terms. The lawyers are negotiating the purchase agreement. There's also a bunch of ancillary agreements that will be negotiated. So for example, there might be a lease agreement, important customer contracts that may need to be assigned, which I know we can hit on later. You know, depending on the structure, if it's an asset deal, meaning the seller selling all of their assets, then you'll attach a bill of sale, assignment and assumption agreements. There may be employment agreements or consulting agreements attached. So really it's much more than just the purchase agreement. There's a lot of agreements involved that the lawyers will be negotiating. And parallel track to this negotiation of the deal documents, the diligence process will be going on at the same time. And both the business folks on either side, as well as the lawyers, will be involved in that process. And that is when the buyer is finding out everything the buyer needs to know before acquiring the business, like you alluded to previously. So very important to understand financials, of course, from the business side, what the customer base looks like. From the legal side, we want to review all of the contracts that the seller has to know if we've got any third-party issues that we need to resolve, or if there are any terms in any of those contracts, if I'm representing a buyer, that I might not recommend my client sign up for. You know, it's important to identify those during the diligence process. So, you know, both of those are really going on at the same time. Once the parties are in agreement on all of the deal terms, and then the diligence process is complete, so the buyer is very comfortable with everything that has been disclosed through diligence, then you're ready to go through the closing process. And that process in itself usually takes about a week, because it's just time to gather signatures. If there's any debt on the company, you'll need to get that debt released and paid off at closing. So reaching out to the banks to get payoff letters. If landlords need to be involved, employees need to sign employment agreements. It's all of that sort of, you know, some of it is administrative, but there is that process that you have to go through. So a lot of times, once parties have agreed to the terms, they're like, okay, well, let's just close tomorrow. And then it just takes time to make sure you dot all the I's and cross all the T's so that you're really ready to get to closing. So there's a lot that goes on, and that's why it can take a longer period of time.
Yeah. So it sounds like the letter of intent is kind of the key business term documents that drives a lot of these other items. I guess when we were talking about before, the way I thought of it is, it's kind of like our CSIA, like SI members' proposals. Like they send something to a customer saying, here's my scope of work, here's what I'm proposing to do, here's what it is. And then they get really frustrated when it comes back and say, yes, that's our deal. And then you actually get the agreement and it looks very little like what that proposal was. It's also these 7 things you didn't agree to do. And also, hey, by the way, taxes are excluded, or, you know, whatever it is. So it sounds like in the same way that our SI members are pretty diligent about defining their proposal and being resistant against their counterparties kind of changing those terms, at least changing those terms without changing the price. It sounds like that's very similar to what you're talking about with the LOI. Yes, it's not binding, but there better be a good reason to kind of vary from its terms when you get to the final agreement, or otherwise people are going to be upset.
Yes, that is exactly correct. And I should have also mentioned, usually the buyer is the one that's proposing the terms in the LOI initially. It can be the seller, but that would be rare. And then the parties go back and forth and negotiate those. So yes, absolutely. The frustration that would be faced if the contract is differing from the proposal, that's, you know, frustration on both the legal side and the business side. Nobody wants to feel blindsided.
Yeah,
so, yes,
some of our participants have gone through that frustration with their daily operations with customers as well. So I'm sure they know exactly what you're talking about there. And you've mentioned a couple of times, you know, the third-party service providers who can really help guide this process, especially if you haven't gone through it before. Can you drill down a little bit? I know we've talked about people like you who are, you know, M&A attorneys, but what other sort of third-party service providers? I know you've mentioned a couple, but maybe it helps to drill down a little bit there.
Yes, sure. So the tax professional be very important, and that can be either from the law firm or from an accounting firm. Most commonly is where that tax professional will come from. And it's important that they are engaged early on both the buy and the sell side, because the structure of the deal is going to drive the tax impact to both the buyer and the seller. And that can be real dollars, significant dollars, depending on what that structure looks like. So that is a very important advisor to get in early on. Also on the accounting side, having an accountant usually an outside accountant helps in addition to the CFO if the business has a CFO or other accounting in-house. That in-house accounting is working closely with the external accountants to prepare all the materials for the financial diligence. So again, both on the buy or sell side, I would say all of these advisors are important on both sides, especially the, tax, M&A, and accounting. So they are, really understanding the numbers. And then the investment banker is the one that runs the competitive process. Very important on the sell side, but buy side also will have investment bankers out there looking for the deals. And in addition to running the process that identifies the buyer or the seller, the bankers really help drive the deal. So if there are certain business discussions or negotiations where the parties are getting stuck on, having the investment banker who's able to act as the intermediary, or maybe things get heated, perhaps, rather than the business folks on either side discussing directly, some of those more difficult conversations can go through the investment banker. So they just help make it be a more smooth process. And then especially on sell side, for a owner who hasn't been through the process before, if it's emotional because it's their baby that they've built up, or, even if they're one of the serial entrepreneurs, they just want to make sure that the process is being run correctly and that, they're not being railroaded, so to speak, by a buyer. Just to have somebody there who has been through a number of deals, can advise on, whether these terms are reasonable, or how to look at things from the business side. I think the banker is really good at that, whereas the M&A attorney can give those sorts of reassurances on the legal side.
It seems like the investment banker in some ways is similar to like what you and I do, in that we're kind of a wide angle lens, right? Because we see a lot of different deals in a lot of different markets with a lot of different players. And so you kind of say, well, that's reasonable. Other people do it a similar way. Or, hey, you're being unreasonable here. This isn't, yes, that's a good idea, but like you're really pushing the envelope on what other parties would agree to. I've also thought of the investment bankers or iBankers, their real goal is to get the deal done one way or the other, because they typically get paid at closing, right? So it's like, they're the ones really saying, how about a phone call tomorrow? How about this? When like sometimes the accountants and, other people doing the diligence are like, what about next week? So they can be useful to kind of drive the deal in more ways than one, I suppose, right? So.
Yes. And on legal side too, you may, on either side, the buyer or the seller may be interacting with more than just the M&A attorney. But, sometimes I say we act as the quarterback, because we are, laying out the plays and we'll identify issues, but then bring in other specialists as needed. So a lot of times the M&A counsel is the main point of contact, but say some employment issue has arose, or, something related to the terms in the lease agreement, if there is one, a real estate specialist may be brought in. So then those other lawyers will touch pieces of the transaction, but it's really the M&A lawyer who's the main point of contact and making sure the, deal as a whole is working from the legal side.
Great. So now that kind of the process is laid out and the parties are kind of identified, for people who might be thinking about in the next 6 months or year, 3 years, 5 years, if they kind of want to maximize how much value they're going to get from selling their business, are there tips or tricks that you can give them that would be important for them to know today for something that might not happen for quite some time in the future?
Yeah, so really considering where the market stands and what your market trends are and what that looks like is important, because you want to sell at the right time. And that's, really what has driven M&A activity last year was extremely busy, just because those trends and market conditions were such where it was very beneficial for a seller to sell at that time. So I know, I'm sure all the participants are very familiar and are tracking all of these things. The bankers can also help with understanding when the right time to sell is as well. So really the the growth drivers, which I understand there are many of them that are in play in this industry, and that there should be some strong long-term growth, which will be very beneficial for a potential seller. Doesn't seem like that's something that's going to go away anytime soon. So you'll have the time to do the advanced planning. In addition to market, things that perhaps a buyer has a little bit more, or a seller, I'm sorry, has a little more control over. So to the extent you're specialized, that can be a driver to increase demand for a strategic acquirer, because perhaps there's a specific area that a buyer would like to go into, and it's going to be easier for them to buy a business that already specializes in that area rather than trying to start it from the ground up themselves. So I think that specialization is important, and just asking yourselves questions about why you would be the best choice for a potential buyer, whether it's the type of solutions that you're able to implement. Perhaps it's your customer base, any IP software that you have, if you are focusing on a certain geography. So those are all things that a seller can be thinking about, again, to figure out how to position themselves in the best way so that they can really drive that the sale price to maximize on the growth that's happening in the industry, or whatever they've done within their business to position themselves well. There's also something called a quality of earnings report. It's a Q of E, and this is something that the accountants will come in and work on both the buy and the sell side. These quality of earnings reports have become much more popular in the past year or so. Like, I used to do deals where we would very rarely see them, or maybe it was only a very large transaction where one party would obtain the Q of E, usually the buyer. But now they're important because both sides just want to prove out their valuation, and that's what that report does. So a seller who's decided that they want to sell their business, during that front end work, when they're engaging the accountant and going through and preparing all of the financial diligence, a lot of times it's a good idea to just go ahead and get that report so that you can prove your value at the front end. So I would say, those are the types of considerations that a seller should have in mind if they're considering selling.
Yeah, it seems like, sometimes in the CSIA groups, we talk about best practices. That's kind of one of the big push drivers for this. It seems like a quality of earnings report, even if you're not kind of on the verge of a transaction, may help prove to yourself kind of, hey, are there some holes or some deficiencies in our operations or in the way that we're running the business, that yes, eventually these may make us more attractive to a potential acquirer. But even before that, it may help us improve internally in the way that we're running the business and improving the quality of our own earnings while they're still ours, which seems like it might be a benefit as well.
Yes, exactly.
So when we're talking about the values, I mean, how, on the other side of this, how do the buyers, like, how do they come up with the value? I mean, are they just, I assume they're not plucking numbers out of thin air, and it's more than just a hunch, though maybe it's more of a hunch than any of us would care to admit about how much a business is worth. But how do you see the value being established between the parties?
I think probably where this varies a little bit is the type of buyer, whether they're a strategic buyer versus a PE, private equity buyer, for example. So for a strategic, in addition to looking at the current financials and where they see that going with the business that they're looking to acquire, they're also going to consider synergies and how combining the seller's business with their own will maximize impact for the buyer. So that's something that should be considered as well, in addition to just what the financial performance of the seller looks like. For PE, I would say they're more looking at the financial performance, trying to bet where that's going to go, and then what their future sale transaction can be. Because in my experience with my private equity clients, they're looking to hold that asset for a certain period of time, maybe 3 to 5 years. And then at that point, they want to sell and then maximize on that investment and get a significant return on their investment that then gets distributed out to the investors with the PE fund. So I think depending on what the buyer's long-term goal is, which is going to vary if it's PE versus strategic, is going to influence exactly what the buyer's looking at in terms of driving the value. And of course, if you're in a competitive process, the buyer is going to be considering, who else is up potentially on the sidelines. They won't know who the other potential buyers are, but they will perhaps have an idea. And if they know that there's somebody else, that's going to drive value, just like any other, demand type of situation is going to drive the value. So I would say that is an influence as well. If the buyer knows there's others out there versus a situation where that buyer is the golden buyer for whatever reason.
Mm-hmm. So it seems like, if I'm hearing this correctly, that there would be a couple different ways to establish the value, and it might change depending on kind of what the hold period is. Like a strategic buyer who's thinking about, either adding capabilities their existing business doesn't have, and rather than organically try to hire people and gain that skill just to kind of buy it and bring it into the fold, they might have a different time period in which they're looking at the return on that investment versus a private equity shop who's like, hey, we're in for 3 to 5 years and then we have to get out because that's what our fund documents call for or generally require. And that how much value can we extract out within that period of time would be different than a strategic buyer. Is that part of the reasons for the difference, is just how long the investment's for?
Yes, I think that's exactly right.
Okay, yeah. And we have a question, which I'm not sure we have enough of a data set at our fingertips to answer this on the multiples, but maybe part of this we can address today. On the transactions that you're seeing, they're asking if this is based mostly on multiples of total revenue, net income, or some other sort of financial metric is kind of just a basic baseline. I'm not sure we'll be able to talk about specific multiples and a specific year for a significant specific industry segment at our fingertips, but we're happy to follow up with people on that. But maybe that other part about kind of just rough cuts on financial metrics, which one tends to get the most focus in your experience?
Yes. So it's always a multiple of EBITDA, almost exclusively is what I've seen in deals. And like you mentioned, we can, come back on what the specific multiples have been, because it has been very industry specific, but I would say in terms of what it's based on would be EBITDA. Okay,
and that's earnings before interest, tax, amortization. Tax. I have that right? Okay.
Depreciation and amortization. So
almost got it.
I know the D is hard to pronounce in there, so yes, that's what it is.
Yeah, it always throws me off, and that's why we have people like you who know this stuff inside and out, and that way I don't have to remember it. Yes. So that's great. Yeah. What if there's a gap, right? It's like there's a seller who thinks their business is worth $1 billion, and everyone else is telling them it's worth $800 million. Just throwing out numbers. I mean, what are some of the ways that like you can get to yes when there's some difference in opinions on what the value of the company? Because it sounds like even in the best circumstances with quality of earnings report and everything else, some of it is just going to be a kind of judgment call based on business professionals, and that it's much more of a art than a science when it gets down to the absolutely final closing value.
That's right. And we've seen more of this recently, and especially as economic conditions change, you see some, differences, because as the future looks uncertain in certain areas, and this is industry specific as well, where the most uncertainty lies. But one way that gap gets bridged is what's called an earnout. So a certain portion of the purchase price will be paid at closing, and then the parties agree that based on future performance, whether that's 12 months, 24 months, 36 months, I would say usually you don't look out further than that. I would say 12 to 24 months is the most common, but you'll say, additional portion of purchase price will be paid if certain metrics are met. And those financial metrics can vary greatly in deals. So it again might be based on EBITDA or adjusted change in adjusted EBITDA perhaps, or maybe it's going to be sales driven or gross profit driven. Perhaps it's a combination of both. And so really the buyer's saying, okay, well, prove it, seller, I want you to prove it. And then you're going to have this period of time to prove it. And then once those metrics are hit, then the remaining purchase price that took the form of an earnout will be paid. And if there's a owner who is not quite ready to completely give up their involvement in the business, they're going to be much more amenable to having an earnout situation because they want to have some control over how the business is going to operate post-closing. This is a hot topic of negotiation, of course, when there's an earnout, because the buyer wants to come in and say, well, I'm going to be able to operate the business the way I want to. I've just spent $100 million or whatever it is. Whereas the seller wants to be sure that they have the opportunity to maximize the earnout as much as they can. And really the parties should be aligned because the buyer is going to want the business to perform well after closing as well. So for the most part, interests are aligned, but kind of the language around the fringes, so to speak, gets heavily negotiated. But I would just say that earnout is a good way to bridge that gap, especially if the owner is willing to stay on. I would see situations where if an owner is just ready to be done and take their money and go live in the Bahamas on the beach, then perhaps they're not going to want to agree to the earnout because they won't have, control or insight into what those operations look like. But it's also not unheard of for a seller who's no longer involved or an owner of the seller no longer being involved, still agreeing to the earnout, just if the parties aren't able to get there on the purchase price while they're negotiating the deal.
So I assume the converse is true. I mean, this is saying, hey, I'm going to it's a $10 million deal. I'll put $8 million in upfront and then $2 million in earnout. And if it hits these metrics, it's paid. I'm assuming, if I'm hearing this right, the converse is true. If it doesn't hit those metrics, that $2 million is not paid. Okay.
Correct. Yes. Correct. Yes.
Okay. So it's kind of in the deal up front. In other words, the financing's in place to pay it and everything else, but the actual distribution to the seller isn't, 12 months, 24 months, 36 months, whatever that period is. Okay.
Yes. Yes, that's right.
Yeah. And it does seem, I could see how that could be up for debate or discussion, because in some ways, if you're the buyer saying, well, I just gave you $8 million, I want to run it. And the other one saying, yeah, but that extra $2 million, I don't want you to get in there and mess it all up. I want the $2 million. So I need to have some amount of control. It seems like that could be something where your advisors can help kind of lead the way on that. So we've talked a little bit about this diligence process and how that all works. And we talked about most from the seller side. If you're thinking about selling your business, kind of how to put that together. Can you talk a little bit from the other side? If maybe you're looking to acquire another company, if you say, hey, I think there's a great market opportunity to do cyber consulting or to get into wastewater treatment facilities or to work on battery technologies, and you just don't have the in-house capabilities, so you're looking kind of to the market. What are some of the important parts of the diligence process from the buyer's side?
Yes, so both legal and business is going to be very important. So you get a lot of folks involved. Just what this looks like if somebody hasn't been involved in the process is there's a virtual data room usually where a whole bunch of documents are going to be uploaded. So you are, as the buyer, looking through financials, of course, and that's where it's important to have, your third-party financial advisors to the extent that they can be helpful to just prove out the value and be sure that it's going to be a good investment that you will get a return on, depending on whatever your holding period looks like, depending on what type of buyer you are. You are going to want to understand the key customers and suppliers, know what the terms of those agreements are, especially if there's a long-term agreement that the buyer is going to be stepping into, making sure they understand what those terms are. If there's any IP that is essential to the business, you'll want to make sure that the seller actually owns that IP and there's not going to be a potential third-party claim against that IP that's going to creep up after you close on the sale transaction. Real estate can be important depending on whether the property is owned or leased. again, the financials, tax impact, understanding if there have been any prior tax issues in the business that will need to be resolved. Data privacy and cybersecurity is becoming increasingly important, especially as regulations will be changing, both on the federal and the state side surrounding those issues. So just understanding what policies are in place, what sort of key customer data the seller may have acquired and what they're doing with that data. And then, employees and employee benefits are very important areas as well. Employees are often the key drivers of the success of the business. So understanding, who those key employees are, whether they're likely to stay on after closing, if they have employment agreements, what those employment agreements look like, and so the buyer can consider whether the buyer is willing to give those same terms or perhaps better terms to an employee post-closing to try to convince them to stay. And then understanding employee benefits, important both from a legal side, because depending on the structure of the deal, making sure that the benefit plans work with existing benefit plans that a buyer has in place, and then just also understanding what the employees have, because especially in industries where success is going to be driven by those employees, you want to make sure that that process is going over smoothly for the employees and that they're happy and want to stay on after the deal closes, so that the business can be as valuable or successful as the buyer is hoping it will be.
Yeah, it seems like it's tough, even with no changes, to keep really qualified, high-performing personnel on staff. If you say, "Hey, I'm selling the business, and by the way, we don't know what's going on with your 401k plan, or whatever other how many vacation days you get, or something like that," it seems like that would be even more difficult. In the industry that we're talking about today, the kind of systems integration industry, obviously, there's a lot of competitors internally that kind of all know each other. What if the potential business partners, the one buying the other one in an M&A transaction, are competitors? Is there anything unique about that circumstance they'd have to be on the lookout for?
Yes, absolutely. And so antitrust considerations and, anti-competitive considerations legally, in addition to, concerns on the business side, this can be an area where companies can inadvertently get into trouble if they don't have the right protections in place. So just because it's a competitor doesn't mean you can't do the deal. There are just extra steps that need to be put in place. So both sides need to carefully consider who has access to the confidential information. So within those virtual data rooms I mentioned, there's often what's referred to as a clean room, where that super competitive or confidential information, things like customer lists, pricing, that sort of information is only going to be placed in this clean room. And perhaps at first, only the third parties have access to that, or only, the most important decision maker at the buyer will have access to that information, so that you're protecting that as much as possible. It's often not uncommon for specific customer information to not be revealed until right before closing. So sometimes that can be frustrating for a buyer, but the seller wants to protect that information and be sure that the buyer isn't going to come in and try to go steal those customers or use that pricing to be able to compete with the seller in a way that would be unfair, that they wouldn't otherwise have access to that information. Another way that a deal can be structured that we haven't really mentioned yet is whether it's a simultaneous sign and close, meaning when you actually sign, you close on the same day, or if it's a two-step transaction where you will have a signing and then a separate closing, like when I sold my house and was frustrated with that. So perhaps the seller isn't going to be comfortable sharing that information until they have a signed purchase agreement with very specific covenants and perhaps termination rights. The parties can only get out of this purchase agreement in a narrow set of circumstances. So then the seller has comfort after they have that signed agreement. And then during that period between signing and closing is when the confidential information will be shared with the buyer.
So the simultaneous closing is sort of all in one shot. And if I know the story right, I think the purchase of Twitter was a sign and then close, or maybe not close later. Is that a good example of the latter type?
Yes.
Okay.
Yes, that's right. That's right. And there could be a variety of reasons. There might be, sometimes there's regulatory approvals that need to happen, especially if there's a competitive business and you meet a certain threshold, then there's what's called an Hsr filing required under the Hart-Scott-Rodino Act, where you submit the deal. And I believe it's over $100 million deal is what the threshold is these days. But then you actually have to submit the deal, and it gets reviewed by the DOJ and the FTC to be sure that it's up to par with their standards, that it's not going to have anti-competitive effects in the business. So if you're over that deal size, and then you have that filing and approval that needs to take place, then you have to do a separate sign and close. Also, if we mentioned third parties a little bit, so say a customer contract has a provision that says, if you sell the business, you need my approval. Otherwise, I get to terminate this contract immediately. So then you need that customer's consent before the buyer gets the benefit of that contract. It's possible the seller's not comfortable going to that buyer, or the seller's not comfortable going to the customer until they know that they've got the buyer signed up to a purchase agreement. So that's another consideration of what can drive that structure in terms of whether it's simultaneous or having the period between signing and closing.
And it seems like with the SI members, there's at least a couple of unique items that may impact on that. One is that if you have controlled technology, like for the people on the phone who deal with ITAR or one of the other, controlled technology regulations, like certain people can't have access to that intellectual property or that software. So, you might need to have a deal and then make sure everyone who has access to that through a clean room is kind of ITAR authorized, especially for international transactions. And then, as you mentioned, a lot of these larger customers that many of the SI members are working for have, maybe I wouldn't quite call them onerous terms, but certainly aggressive terms. And they may have a lot of control over what a business is and is not allowed to do while they're either preferred vendor or under some sort of a master services agreement, a longer term arrangement than just a particular engagement. And having seen a lot of these, a lot of times they do say a change in control of the company would entitle a termination right to be triggered unless there's prior approval. So you'd hate to find out that you have a great sale on the board and then the customer that represents 40% of the revenue decided, yeah, we don't want to do that. We're not going to give consent. And by the way, that long-term revenue stream is no longer available to you. It seems like that's a big wrench to throw in the deal at the 11th hour. So
yes, exactly. And that would be one of the limited circumstances, perhaps, when the buyer could get out. They would negotiate for that. Like if you're not able to get these key consents, then we're able to terminate the deal, even though we have a signed purchase agreement, without any negative effects to the buyer, because that's such a key part. So all of those are types of things that would be negotiated. And then not to go back to diligence, but also why that diligence process is so important, because that's how you're going to identify those issues that then need to be negotiated and reflected in your purchase agreement.
So you talked a little bit also about kind of the employees part of this. As we mentioned, it's such an important part of any SI member. It's really driven by multiple people. Part of it's the sales force and part of it's the HR people, but a lot of it is the talent, the engineering talent, the project management talent. What do you see being done to make sure that that part of the value of the company, not just the customer relationships and the supplier relationships and the historic revenue streams and all the financial calculations, what do you do about the employees who might contribute a lot of the value to the company post-closing?
I'll respond to this on both the sell side first and then the buy side, because there's different considerations on each of those sides, not surprisingly. So for the seller, they often want to make sure that their employees are taken care of after the deal closes. They might be folks that were in the trenches with them from the very beginning. Maybe they're a 30-year employee that has been key to the business. So the seller wants to be sure that they're treated fairly after closing. And the seller can require that before closing, there's an employment agreement that the seller's employees agree to. The buyer is going to resist that because they don't, potentially then some employee could hold up the deal. But especially if it's somebody that's key to the deal, then the buyer might want that as well. So you make it what's called a condition to closing. So you're not going to close the deal until you've got those employee terms agreed to. And that's one way that the seller can protect its employees post-closing. You can also include covenants or agreements in the terms that say their salary and benefits need to be comparable or better than what they had at the seller. Did I lose you for a second?
Just for 1 second, but then you came right back.
Came right back. Okay.
I glitched in the matrix. I think we're good.
Okay. So I was saying, so did you get what I said about, comparable benefits and things like that? And then also a seller should consider how to keep their employees motivated through the sale process. So sometimes not all employees are going to know about the sale process, of course, especially you might not want the whole company to know, but your key folks, like your CFO, for example, your key management is going to need to be involved in diligence and all of that. So keeping them motivated, because now all of a sudden they're going to be doing two jobs, like the regular job, and then having to go through the sale transaction. So oftentimes a seller might give a sale bonus to the employees. So if the sale successfully goes through, you get X% at closing, or you're going to get a $50,000 bonus, or whatever it is. It's those terms, of course, can vary widely, but it's important for the seller to be sure that their key folks are involved to get through that sale process. And then also on the sell side, I would say that it's also important for the owner perhaps to consider whether they want to stay on post-closing. So do they want an employment agreement that they want to have negotiated? Especially if there's some sort of an earnout, do they want to have an employment agreement with severance? So they know, I am going to stay on, and if they just terminate me for no reason, then I'm going to be entitled to some sort of a payout. Or perhaps the owner doesn't want to be so involved that they're signed up to a full-fledged employment agreement, but they're willing to be a consultant for a certain transition period. So those are all considerations on the sell side. And I would say on the buy side, if they're those key employees that the buyer wants to make sure are staying on post-closing, then the buyer will also want to have those employment agreements signed up. Alternatively, if it's employees that are not key, then a buyer is not going to want a requirement that all of those employees have signed employment agreements, because as I alluded to just previously, that would give an employee the power to hold up the deal, so to speak. So if the seller says, well, all my employees have to have signed employment agreements with you, the buyer is going to greatly resist that, because then when an employee figures that out, like, oh, this deal isn't going through unless I sign up, agree to this employment agreement, they could potentially hold things up. So there's, some competing interests on either side, but for those key folks, it usually tends to be a situation where buyer and seller are on the same page, because they want to make sure that those key employees are staying on and able to drive the success post-closing.
Well, that's great. And that's probably a good place with talent, where we all focus a lot of our attention to probably wrap up. Jennifer or Lefa, if you could put up the slide, and we'll wrap up here. Just as a reminder for the people who were able to join us today, all CSIA members are automatically part of the CSIA Legal Plan available from the organization that gives you access to me and to Brittany and the rest of our 1,200 legal colleagues across the country. You have the right to discounted legal services. Some of those are absolutely free. So the Q&A sessions with some of our automation and robotics attorneys are free, and there's discounts available for all sorts of items, including for contract related purposes. And certainly if you want to follow up with Brittany on any specific questions you have about any M&A transactions or thinking about the future, you can go to the controlsys.org website and look for the legal plan. With that, I will turn it back over to Lisa.
On behalf of CSIA, I would like to thank our panelists, Brittany and Brian, for this informative discussion. I would also like to thank, this is the firm name, Faegre, and all the other people attached to Faegre for presenting this event. And of course, thank you for attending. I'd also like to remind you that a recording will be available for viewing within the next couple of days. And be sure to bookmark the CSIA events calendar so you don't miss any upcoming events. One last housekeeping item. If you have not created your account in the new CSIA membership database, please do it today. You can find out how at www.controlsys.org/account. This concludes our program for today. Once again, thank you for joining us and have a great day.